Section 7, Answer Key National Test 1, Rights, Interests and Estates, Ownership 1.1, A. Wells, driveways, and signs on a parcel of land. The legal concept of real estate encompasses land and all man-made structures that are permanently attached to the land. The phrase permanently attached refers primarily to one's intention in attaching the item. Obviously, very few if any man-made structures can be permanently attached to the land in the literal sense. But if a person constructs a house with the intention of creating a permanent dwelling, the house is considered real estate. By contrast, if a camper affixes a tent to the land with the intention of moving it to another camp in a week, the tent would not be considered real estate. 1.2 C. A chicken coop permanently attached to land. Improvements to real estate include such things as fences, streets, buildings, wells, sewers, sidewalks, and piers. Modifications to land or a developer's preparations of a parcel of land can include such activities as grading or clearing, neither of which are considered to be improvements in the sense of the word. 1.3 B. The center of the earth and infinite space above the earth. The legal concept of land encompasses the surface area of the earth, everything beneath the surface of the earth extending downward to its center, all natural things permanently attached to the earth, and the air above the surface of the earth extending outward to infinity. Land, therefore, includes minerals beneath the earth's surface, water on or below the earth's surface, and the air above the surface. 1.4 A. Enjoyed by the owner of a property. This group of rights includes the right to possess, use, transfer, encumber, and exclude others from using the property. Remember, putti, transfer rights include the right to sell, rent, donate, assign, or bequeath. The owner may also encumber the item by mortgaging it as collateral for debt. 1.5 B. Any item of property that is not definable as real property. Personal property is any owned item which is not real estate, and the rights associated with owning the personal property item. Items of personal property are also called chattels or personalty. 1.6 B. Pledge the property as collateral for debt. The right to encumber the property essentially means the right to mortgage the property as collateral for debt. There may be restrictions to this right, such as a spouse's right to limit the degree to which a homestead may be mortgaged. 1.7 A. Transfer of a portion of the bundle of rights. An ordinary lease is a common example of the transfer of a portion of one's bundle of rights. The owner relinquishes the right to possess portions of the surface, perhaps a building, in return for rent. The tenant enjoys the rights to possess and use the building over the term of the lease, after which these rights revert to the landlord. During the lease term, the tenant has no rights to the property's subsurface or airspace other than what the building occupies. Further, the tenant does not enjoy any of the other rights in the bundle of rights. He or she cannot encumber the property or transfer it. To a limited degree, the tenant may exclude persons other than the legal owner from the property. 1.8 D. Yes. The drones infringe on his air rights. Air rights apply to the space above the surface boundaries of the parcel, as delineated by imaginary vertical lines extended to infinity. Since the advent of aviation, property owners' air rights have been curtailed to allow aircraft to fly over one's property provided the overflights do not interfere with the owner's use and enjoyment of the property. The issue of violation of air rights for the benefit of air transportation is an ongoing battle between aircraft owners, airlines, airports, and nearby property owners. 1.9 C. Navigable lakes, seas, and oceans. Littoral rights concern properties abutting bodies of water that are not moving, such as lakes and seas. Owners of properties abutting a navigable, non-moving body of water enjoy the littoral right of use, but do not own the water nor the land beneath the water. The legal premise underlying the definition of littoral rights is that a lake or sea is a navigable body of water, therefore, public property owned by the state. By contrast, a body of water entirely contained within the boundaries of an owner's property is not navigable. In such a case, the owner would own the water as well as unrestricted rights of usage. 1.10 A. The high water mark of the body of water at the shoreline. Ownership extends to the high water mark of the body of water. The low water mark would imply that the owner owned the water itself at times of high water levels. 1.11 D. They transfer with the property when the property is sold. Littoral rights attach to the property. When the property is sold, the littoral rights transfer with the property to the new owner. 1.12 C. Streams and rivers. Riparian rights concern properties abutting moving water such as streams and rivers. If a property abuts a stream or river, the owner's riparian rights are determined by whether the water is navigable or not navigable. If the property abuts a non-navigable stream, the owner enjoys unrestricted use of the water and owns the land beneath the stream to the stream's midpoint. If the waterway in question is navigable, the waterway is considered to be a public easement. In such a case, the owner's property extends to the water's edge as opposed to the midpoint of the waterway. 1.13 B. An item of personal property that has been converted to real property. A personal property item that has been converted to real property by attachment to real estate is called a fixture. Typical examples are chandeliers, toilets, water pumps, septic tanks, and window shutters. The owner of real property inherently owns all fixtures belonging to the real property. When the owner sells the real property, the buyer acquires rights to all fixtures. 1.14 A. The owner originally intended to remove it after a period of time. One's original intention can override the test of movability in determining whether an item is a fixture or not. If someone attached an item to real property, yet intended to remove it after a period of time, the article may be deemed personal property. If a person intended an article to be a fixture, even though the item is easily removable, the article may be deemed a fixture. For example, an apartment renter installs an alarm system, fully intending to remove the system upon lease expiration. Here, the alarm system would be considered personal property. 1.15 c. 50% of the estate consisting of the indivisible whole of the real property. An undivided interest is an owner's fractional interest in an entire, undivided, estate, but not in a physical portion of the real property itself. An owner who has an undivided equal interest with another cannot exercise exclusive rights over a portion of the real estate, which is an indivisible whole. 1.16 a. An estate in land. Interests are principally distinguished by whether they include possession. If the interest holder enjoys the right of possession, the party is considered to have an estate in land, or, familiarly, an estate. Freehold and leasehold estates in land are further distinguished by whether the duration of the owner's rights can be determined. 1.17 a. A public interest. Public entities may own or lease real estate, in which case they enjoy an estate in land. However, government entities also have non-possessory interests in real estate which act to control land use for the public good within the entity's jurisdiction. The prime example of public interest is police power, or the right of the local or county government to zone. Another example of public interest is the right to acquire ownership through the power of eminent domain. 1.18 c. A freehold estate. In a freehold estate, the duration of the owner's rights cannot be determined. The rights may endure for a lifetime, for less than a lifetime, or for generations beyond the owner's lifetime. By contrast, leasehold estates have expirations. 1.19 d. That the estate is limited by a lease term. A leasehold estate is distinguished by its specific duration, as represented by the lease term. Further, leasehold tenants only enjoy limited property rights, use, temporary possession, and limited exclusion. 1.20 d. Fee simple defeasible. The defeasible fee estate is perpetual, provided the usage conforms to stated conditions. Essential characteristics are that the property must be used for a certain purpose or under certain conditions, and, if the use changes or if prohibited conditions are present, the estate reverts to the previous grantor of the estate. 1.21 c. An ordinary life estate. A life estate is limited in duration to the life of the owner or other named person. Upon the death of the owner, ordinary life estate, or other named individual, per otravi life estate, the estate passes to the original owner, a reversionary interest, or another named party, a remainder interest. Thus with the life estate, the owner enjoys full ownership rights during the estate period, and holders of the future interest own either a reversionary or a remainder interest. 1.22 b. A legal life estate. Homestead, dower, and curtsy are legal life estates. A legal life estate is created by state law as opposed to being created by a property owner's agreement. The focus of a legal life estate is defining and protecting the property rights of surviving family members upon the death of the husband or wife. 1.23 b. The boat, house, and motorcycle. Separate property consists of property owned by either spouse at the time of the marriage, property acquired by either spouse through inheritance or gift during the marriage, property acquired with separate property funds, and income from separate property. Community property consists of all other property earned or acquired by either party during the marriage. A spouse owns separate property free and clear of claims by the other spouse. He or she can transfer it without the other spouse's signature. Upon the death of the separate property owner, the property passes to heirs by will or laws of descent. Community property cannot be transferred or encumbered without the signatures of both spouses. Upon the death of either spouse, half of the deceased's community property passes to the surviving spouse, and the other half passes to the decedent's heirs. 1.24 d. The right to possess and use the premises. Leasehold tenants are entitled to possess and use the leased premises during the lease term in the manner prescribed in the lease. They also have restricted rights to exclusion. 1.25 a. The tenant makes, and landlord accepts, regular rent payments. In an estate from period to period, also called a periodic tenancy, the tenancy period automatically renews as long as the tenant pays rent in a timely manner and the landlord accepts it. At the end of a tenancy period, if the landlord accepts another regular payment of rent, the leasehold is considered to be renewed for another period. A conveyance of leased property does not cancel a leasehold interest. 1.26 c. Terminates on the death of lessor or lessee. The estate at will, also called a tenancy at will, has no definite expiration date and hence no renewal cycle. The landlord and tenant agree that the tenancy will have no specified termination date, provided rent is paid on time and other lease conditions are met. For example, a son leases a house to his father and mother forever, or until they want to move. The estate at will is terminated by proper notice, or by the death of either party. 1.27 a. An estate at sufferance. In an estate at sufferance, a tenant occupies the premises without consent of the landlord or other legal agreement with the landlord. Usually such an estate involves a tenant who fails to vacate at the expiration of the lease, continuing occupancy without any right to do so. For example, a tenant violates the provisions of a lease and is evicted. The tenant protests and refuses to leave despite the eviction order. 1.28 b. Estate from period to period. In an estate from period to period, also called a periodic tenancy, the tenancy period automatically renews for an indefinite period of time, subject to timely payment of rent. At the end of a tenancy period, if the landlord accepts another regular payment of rent, the leasehold is considered to be renewed for another period. 1.29 a. Tenancy in severalty. If a single party owns the fee or life estate, the ownership is a tenancy in severalty. Synonyms are sole ownership, ownership in severalty, and estate in severalty. 1.30 c. Tenancy in common. The tenancy in common, also known as the estate in common, is the most common form of co-ownership when the owners are not married, though tenants in common can be married. The defining characteristics are, 2 or more owners, identical rights, interests individually owned, electable ownership shares, no survivorship, and no unity of time. With identical rights, co-tenants share an indivisible interest in the estate, i.e., all have equal rights to possess and use the property subject to the rights of the other co-tenants. 1.31 a. Parties must acquire respective interests at the same time. To create a joint tenancy, all owners must acquire the property at the same time, use the same deed, acquire equal interests, and share in equal rights of possession. These are referred to as the four unities. 1.32 b. Cannot will their interest to a party outside the tenancy. The survivorship feature of joint tenancy presents an advantage to tenancy in common, in that interests pass without probate proceedings. On the other hand, joint tenants relinquish any ability to will their interest to parties outside of the tenancy. 1.33 c. Legal life estate. A legal life estate is created by state law as opposed to being created by a property owner's agreement. The focus of a legal life estate is defining and protecting the property rights of surviving family members upon the death of the husband or wife. 1.34 a. A homestead interest cannot be conveyed by one spouse. A homestead is one's principal residence. Homestead laws protect family members against losing their homes to general creditors attempting to collect on debts. Homestead laws generally provide that the homestead interest cannot be conveyed by one spouse, both spouses must sign the deed conveying homestead property. 1.35 a. Sell or transfer his interest without the consent of the other tenants in common. All tenants in common have distinct and separable ownership of their respective interests. Co-tenants may sell, encumber, or transfer their interests without obstruction or consent from the other owners. A co-tenant may not, however, encumber the entire property. 1.36 c. Income derived from community property. If an income-producing property has been defined as community property, the revenue accruing from the investment is likewise community property. 1.37 c. The beneficiary. A land trust allows the trustor to convey the fee estate to the trustee and to name himself or herself the beneficiary. The land trust applies only to real property, not to personal property. The agreement, or deed in trust, grants the beneficiary the rights to possess and use the property, and to exercise control over the actions of the trustee. 1.38 c. The Buick and the Second Property Community property laws define property rights of legal spouses before, during, and after their marriage, as well as after the death of either spouse. Community property law distinguishes real and personal property into categories of separate and community property. Separate property belongs to one spouse, community property belongs to both spouses equally. Separate property is that property which is acquired prior to the marriage, by gift or inheritance during the marriage, property acquired by separate property funds, or income from separate property. 1.39 a. A cooperative may hold an owner liable for the unpaid operating expenses of other tenants. Since the corporation owns an undivided interest in the cooperative property, debts and financial obligations apply to the property as a whole, not to individual units as in a condominium. 1.40 b. The owners enjoy an indivisible interest. The tenancy in common, also known as the estate in common, is the most common form of co-ownership when the owners are not married, though tenants in common can be married. The defining characteristics are, two or more owners, identical rights, interests individually owned, electable ownership shares, no survivorship, and no unity of time. With identical rights, co-tenants share an indivisible interest in the estate, i.e., all have equal rights to possess and use the property subject to the rights of the other co-tenants. 1.41 a. Sell her interest to a third party without the consent of Robert. All tenants in common have distinct and separable ownership of their respective interests. Co-tenants may sell, encumber, or transfer their interests without obstruction or consent from the other owners. A co-tenant may not, however, encumber the entire property. 1.42 d. It passes by probate to the deceased tenant's heirs. A deceased co-tenant's estate passes by probate to the decedent's heirs and devises rather than to the other tenants in common. Any number of heirs can share in the ownership of the willed tenancy. 1.43 c. The tenants have an equal and indivisible ownership interest. In a joint tenancy, two or more persons collectively own a property as if they were a single person. Rights and interests are indivisible and equal, each has a shared interest in the whole property which cannot be divided up. Joint tenants may only convey their interests to outside parties as tenant in common interests. One cannot convey a joint tenant interest. 1.44 a. There is a single title to the property. Whereas tenants in common hold separate title to their individual interests, joint tenants together hold a single title to the property. This is referred to as unity of ownership. 1.45 a. The new owner becomes a tenant in common with the other owners, who continue to hold a joint tenancy with each other and a tenancy in common with the new owner. A joint tenant may transfer his or her interest in the property to an outside party, but only as a tenancy in common interest. Whoever acquires the interest co-owns the property as a tenant in common with the other joint tenants. The remaining joint tenants continue to own an undivided interest in the property, less the new co-tenants' share. 1.46 d. It passes to the surviving joint tenants. In most states, joint tenants enjoy rights of survivorship. If a joint tenant dies, all interests and rights pass to the surviving joint tenants free from any claims of creditors or heirs. When only one joint tenant survives, the survivor's interest becomes an estate in severalty, and the joint tenancy is terminated. 1.47 c. If they are married. Tenancy by the entire ties is a form of ownership reserved exclusively for husband and wife. It features survivorship, equal interests, and limited exposure to foreclosure. 1.48 c. The trustee. In an estate in trust, a fee owner, the grantor or trustor, transfers legal title to a fiduciary, the trustee, who holds and manages the estate for the benefit of another party, the beneficiary. The trust may be created by a deed, will, or trust agreement. 1.49 a. Sell or mortgage the unit without impediment from individual owners of neighboring units. Condominium units can be individually sold, mortgaged, or otherwise encumbered without interference from other unit owners. An owner may not sell interests in the apartment separately from the interest in the common elements. Unit owners exclusively possess their apartment space, but must share common areas with other owners. 1.50 b. The unit's pro rata share of the property value as defined in the declaration. The unit's pro rata share of the property's ownership as defined in the declaration determines the amount of a unit owner's assessment. For example, if a unit represents a 2% share of the property value, that unit owner's assessment will be 2% of the property's common area expenses. 1.51 a. Shares in a corporation or association and a proprietary lease in a physical unit. In a cooperative, or co-op, one owns shares in a non-profit corporation or cooperative association, which in turn acquires and owns an apartment building as its principal asset. Along with this stock, the shareholder acquires a proprietary lease to occupy one of the apartment units. 1.52 d. The corporate entity of the cooperative association. The corporate entity of the cooperative association is the only party in the cooperative with a real property interest. The association's interest is an undivided interest in the entire property. There is no ownership interest in individual units, as with a condominium. 1.53 a. Undivided interests in the property as tenants in common. In a freehold timeshare, or interval ownership estate, tenants in common own undivided interests in the property. Expense prorations and rules governing interval usage are established by separate agreement when the estate is acquired. National Test 2, Encumbrances, Liens, Title Transfer and Recording, Leases 2.1, c. A third party's interest in a real property that limits the interests of the freehold property owner. An encumbrance is an interest in and right to real property that limits the legal owner's freehold interest. In effect, an encumbrance is another's right to use or take possession of a legal owner's property, or to prevent the legal owner from enjoying the full bundle of rights in the estate. 2.2 a. They involve the property that contains the easement and a non-owning party. An easement is an interest in real property that gives the holder the right to use portions of the legal owner's real property in a defined way. One cannot own an easement over one's own property. Easement rights may apply to a property's surface, subsurface, or airspace, but the affected area must be defined. An easement may be affirmative, allowing a use, such as a right-of-way, or negative, prohibiting a use, such as an airspace easement that prohibits one property owner from obstructing another's ocean view. 2.3 d. An easement appurtenant. An easement appurtenant gives a property owner a right of usage to portions of an adjoining property owned by another party. The property enjoying the usage right is called the dominant tenement, or dominant estate. The property containing the physical easement itself is the servient tenement, since it must serve the easement use. 2.4 C. Easement by necessity. An easement by necessity is an easement appurtenant granted by a court of law to a property owner because of a circumstance of necessity, most commonly the need for access to a property. Since property cannot be legally landlocked, or without legal access to a public thoroughfare, a court will grant an owner of a landlocked property an easement by necessity over an adjoining property that has access to a thoroughfare. 2.5 B. An unauthorized physical intrusion of one property into another. An encroachment is the unauthorized, physical intrusion of one owner's real property into that of another. Examples of encroachments are, a tree limb extending into the neighbor's property, violating his or her airspace, a driveway extending beyond the lot line onto the neighbor's land, and a fence built beyond the property line. 2.6 C. A trespasser has been using an owner's property for a certain period with the owner's knowledge but without permission. If someone uses another's property as an easement without permission for a statutory period of time and under certain conditions, a court order may give the user the easement right by prescription, regardless of the owner's desires. For a prescriptive easement order to be granted, the following circumstances must be true: the use has been occurring without permission or license, the owner knows or is presumed to have known of the use, and the use has been generally uninterrupted over the statutory prescriptive period. 2.7 D. How a property may be used and what improvements may be built on it. A deed restriction is a limitation imposed on a buyer's use of a property by stipulation in the deed of conveyance or recorded subdivision plat. A deed restriction may apply to a single property or to an entire subdivision. A developer may place restrictions on all properties within a recorded subdivision plat. Subsequent resales of properties within the subdivision are thereby subject to the plat's covenants and conditions. 2.8 C. The creditor's claim against the property as collateral security for the loan. A lien is a creditor's claim against personal or real property as security for a debt of the property owner. If the owner defaults, the lien gives the creditor the right to force the sale of the property to satisfy the debt. For example, a homeowner borrows $5,000 to pay for a new roof. The lender funds the loan in exchange for the borrower's promissory note to repay the loan. At the same time, the lender places a lien on the property for $5,000 as security for the debt. If the borrower defaults, the lien allows the lender to force the sale of the house to satisfy the debt. 2.9 D. An equitable interest. A lienor generally has an equitable interest in the property, but not legal ownership. The exception is a mortgage lien on a property in a title theory state. In these states, the mortgage transaction conveys legal title to the lender, who holds it until the mortgage obligations are satisfied. During the mortgage loan period, the borrower has equitable title to the property. 2.10 A. Payment of the debt that is the subject of the lien and recording of the satisfaction. A lien terminates on payment of the debt and recording of documents. Payment of the debt and recording of the appropriate satisfaction documents ordinarily terminate a lien. If a default occurs, a suit for judgment or foreclosure enforces the lien. These actions force the sale of the property. 2.11 d. Involuntary general lien. A general lien is one placed against any and all real and personal property owned by a particular debtor. An example is an inheritance tax lien placed against all property owned by the heir. A specific lien attaches to a single item of real or personal property and does not affect other property owned by the debtor. In addition, judgment liens are junior, involuntary liens. 2.12 a. Real estate tax lien. The category of superior, or senior, liens ranks above the category of inferior, or junior, liens, meaning that superior liens receive first payment from the proceeds of a foreclosure. The superior category includes liens for real estate tax, special assessments, and inheritance tax. Other liens, including income tax liens, mortgage liens, and judgment liens, are inferior. 2.13 d. Subordinate the lien. A liener can change the priority of a junior lien by voluntarily agreeing to subordinate, or lower, the lien's position in the hierarchy. This change is often necessary when working with a mortgage lender who will not originate a mortgage loan unless it is senior to all other junior liens on the property. The lender may require the borrower to obtain agreements from other lien holders to subordinate their liens to the new mortgage. 2.14 c. A proceeding to enforce a lien by forcing the sale or transfer of a secured property. All liens can be enforced by the sale or other transfer of title of the secured property, whether by court action, operation of law, or through powers granted in the original loan agreement. The enforcement proceedings are referred to as foreclosure. Note that lieners already possess equitable title, so they do not need to undertake a legal proceeding to establish this. 2.15 b. File a foreclosure suit. Judicial foreclosure occurs in states that use a two-party mortgage document, borrower and lender, that does not contain a power of sale provision. Lacking this provision, a lender must file a foreclosure suit and undertake a court proceeding to enforce the lien. 2.16 a. Strict foreclosure. Strict foreclosure is a court proceeding that gives the lender title directly, by court order, instead of giving cash proceeds from a public sale. On default, the lender gives the borrower official notice. After a prescribed period, the lender files suit in court, whereupon the court establishes a period within which the defaulting party must repay the amounts owed. If the defaulter does not repay the funds, the court orders transfer of full, legal title to the lender. 2.17 d. A license, which terminates upon the owner's death. A license is a personal right that a property owner grants to another to use the property for a specific purpose, to reach the kindergarten school bus. Unlike a personal easement in gross, which terminates only on the death of the grantee, Betty Lou Ann, in this instance, a license is revocable at any moment, is not. transferable and does not attach to the land. It ceases on the death of either party, or on the sale of the property. 2.18 d. Dominant tenement. An easement appurtenant gives a property owner a right of usage to portions of an adjoining property owned by another party. The property enjoying the usage right is called the dominant tenement, or dominant estate. The property containing the physical easement itself is the servient tenement, since it must serve the easement use. 2.19 b. A deed restriction. A private party who wants to control the quality and standards of a property can establish a deed restriction. Deed restrictions take precedence over zoning ordinances if they are more restrictive. 2.20 a. It involves a monetary claim against the value of a property. A lien is a creditor's claim against personal or real property as security for a debt of the property owner. If the owner defaults, the lien gives the creditor the right to force the sale of the property to satisfy the debt. Liens do not necessarily alter the property value. Liens can be involuntary as well as voluntary. Finally, liens attach to the property, but so do other encumbrances. 2.21 d. It is knowledge received or imparted through direct experience. The term notice is synonymous with knowledge. A person who has received actual notice has actual knowledge of something. Receiving actual notice means learning of something through direct experience or communication. Thus, a document in itself cannot be actual notice. It is the seeing of the document that makes it actual notice. 2.22 b. It is knowledge one could have or should have obtained. Constructive notice, or legal notice, is knowledge of a fact that a person could have or should have obtained. The foremost method of imparting constructive notice is by recordation of ownership documents in public records, specifically, title records. Since public records are open to everyone, the law generally presumes that when evidence of ownership is recorded, the public at large has received constructive notice of ownership. 2.23 a. Grant, deed, and will. Voluntary transfer, or voluntary alienation, is an unforced transfer of title by sale or gift from an owner to another party. If the transferor is a government entity and the recipient is a private party, the conveyance is a public grant. If the transferor is a private party, the conveyance is a private grant. A living owner makes a private grant by means of a deed of conveyance, or deed. A private grant that occurs when the owner dies is a transfer by will. 2.24 c. It gives constructive notice of ownership. Recording is not necessary to make a deed valid. However, it is in the grantee's best interests to do so. Recording the deed gives the public constructive notice of the grantee's ownership. 2.25 b. Granting clause. The granting, or premises, clause is the only required clause. It contains the conveyance intentions, names the parties, describes the property, and indicates a nominal consideration. 2.26 a. General warranty deed. The general warranty deed, or warranty deed for short, contains the fullest possible assurances of good title and protection for the grantee. The deed is technically a bargain and sale deed in which the grantor promises to defend against any and all claims to the title. The overall general warranty covenant is, I own and will defend. 2.27 d. To have an encumbrance removed if the lien holder cannot prove its validity. Where there is a possibility that prior errors in deeds or other recorded documents might cloud, encumber, the title, the relevant parties execute a quitclaim deed to convey any and all interest to the grantee. If a party responsible for encumbering title refuses to quitclaim the interest, the owner may file a quiet title suit. This requires the lienor to prove the validity of an interest. If the defendant is unable to do so, the court removes the cloud by decree. 2.28 a. A transfer tax based on the price of the property being conveyed. State law usually requires payment of a documentary stamp tax on a conveyance of real property. The tax is based on the actual price of the property conveyed, thus enabling taxing authorities to ascertain current market value for ad valorem tax purposes. Payment of the tax is evidenced on the deed. 2.29 b. Probate. A court proceeding called probate generally settles a decedent's estate, whether the person has died testate, having left a valid will, or inte state, having failed to do so. 2.30 a. It will escheat to the state or county. If an inte state decedent has no heirs, the estate escheats, or reverts, to the state or county after all claims and debts have been validated and settled. 2.31 d. Eminent domain. Various government and public entities can transfer private property to the public sphere by the power of eminent domain. The transfer is involuntary, even though the owner receives compensation. For example, a city government wants to widen a highway to accommodate growth. The government uses eminent domain to condemn and purchase all properties abutting the thoroughfare in order to complete the construction project. 2.32 a. Openly possessing and claiming the property without the owner's consent. To claim legal title, the adverse possessor must be able to show a claim of right or color of title as reason for the possession, have notorious possession, which is possession without concealment, maintain a consistent claim of hostile possession, which is a claim to ownership and possession regardless of the owner's claims or consent, occupy the property continuously for a statutory period of time, in some states, pay taxes. 2.33 c. The buyer. Title records protect the buyer by revealing whether a property has marketable title, one free of undesirable encumbrances. The buyer is legally responsible for knowing the condition of title, since it is a matter of public record. 2.34 a. A clouded title. Chain of title refers to the succession of property owners of record dating back to the original grant of title from the state to a private party. If there is a missing link in the chronology of owners, or if there was a defective conveyance, the chain is said to be broken, resulting in a clouded title to the property. 2.35 b. Standard Owner's Title Insurance Policy. An owner's policy may have standard coverage or extended coverage. Standard coverage protects against title defects such as incompetent grantors, invalid deeds, fraudulent transaction documents, and defects in the chain of title. Extended coverage protects against liabilities that may not be of public record, including fraud, unrecorded ownership claims, unintentional recording errors, and unrecorded liens. 2.36 A. Voluntary alienation. Voluntary alienation is an unforced transfer of title by sale or gift from an owner to another party. 2.37 D. A quitclaim deed. A quitclaim deed transfers real and potential interests in a property, whether an interest is known to exist or not. The grantor makes no claim to any interest in the property being conveyed and offers no warrants to protect the grantee. Where there is a possibility that prior errors in deeds or other recorded documents might cloud, encumber, the title, the relevant parties execute a quitclaim deed to convey any and all interest to the grantee. 2.38 A. Passed to the heirs by the laws of descent and distribution. In this circumstance, the estate, including real property, will pass to lawful heirs according to the state's laws of descent and succession or distribution. These laws apportion the estate without regard to the wishes of the heirs or the intentions of the decedent. Escheat, by which the state takes the property, applies only if there are no legal heirs. 2.39 D. Declined because possession was secretive. One of the preconditions for a claim of ownership based on adverse possession is notorious possession, or possession without concealment. Even if the length of possession in this case meets the statutory requirement, the drifter's secretiveness would invalidate the claim. 2.40 B. Free of undisclosed defects and encumbrances. Marketable title is, by definition, one that is free and clear of undesirable and unknown encumbrances, claims, clouds, or other defects. Attorneys' abstracts and title certificates do not guarantee that a title is marketable. 2.41 C. Estate at will. Three of the four principal types of leasehold estate are, the estate for years, which has a specific lease term, the estate from period to period, where the lease term of a specific period automatically renews, and the estate at will, which has no specified lease term. The fourth principal type, the estate at sufferance, is a tenancy without consent that therefore also has no specific term. 2.42 B. For specified reasonable purposes. A tenant has the sole right to occupy and use the premises without interference from outside parties, including the landlord. The landlord may enter the premises for specified purposes such as inspections, but the interference must be reasonable and limited. In addition, the landlord can do nothing outside of the lease's express provisions that would impair the tenant's enjoyment of income deriving from use of the premises. 2.43 A. Compliance with the rules and regulations of the building. The lease defines the tenant's obligations, which principally are to pay the rent on time, maintain the property's condition, and comply with the rules and regulations of the building. 2.44 B. providing required building support and services. The lease defines the landlord's obligations, which principally are to provide the necessary building support and services, and maintain the condition of the property. It is the tenant's responsibility to obtain insurance and to determine the fairness of the rent. 2.45 d. The tenant's estate is still obligated under the lease. A valid lease creates obligations that survive the death of the landlord or tenant, with certain exceptions. A tenant's estate remains liable for payment of rent if the tenant dies. The landlord's estate remains bound to provide occupancy despite the landlord's death. 2.46 a. The remaining tenant is responsible for the full rent obligation. Multiple tenants who sign a single lease are jointly and severally responsible for fulfilling lease obligations. Thus, if one renter abandons an apartment, the other renters remain liable for rent. 2.47 c. Sublease. Subletting, subleasing, is the transfer by a tenant, the sublessor, of a portion of the leasehold interest to another party, the sublessee, through the execution of a sublease. The sublease spells out all of the rights and obligations of the sublessor and sublessee, including the payment of rent to the sublessor. The sublessor remains primarily liable for the original lease with the landlord. The subtenant is liable only to the sublessor. 2.48 d. Net lease. A net lease requires a tenant to pay for utilities, internal repairs, and a proportionate share of taxes, insurance, and operating expenses in addition to rent. In effect, the landlord passes through actual property expenses to the tenant rather than charging a higher rent level. Net leases vary as to exactly what expenses the tenant is responsible for. The purest form of net lease requires tenants to cover all expenses, including major repairs and property taxes. 2.49 a. Gross lease. 2.49 a. Gross lease, or full-service lease, requires the landlord to pay the property's operating expenses, including utilities, repairs, and maintenance, while the tenant pays only rent. Rent levels under a gross lease are higher than under a net lease, since the landlord recoups expense outlays in the form of added rent. 2.50 b. An owner-developer wants to retain ownership of the land portion of the improved real property. Ground leases are primarily used when an owner wishes to lease raw land to an agricultural or mining interest, when unimproved property is to be developed and the owner wants to retain ownership of the land, when the developer or future users of the property do not want to own the land, or when the owner of an improved property wishes to sell an interest in the improvements while retaining ownership of the underlying land. 2.51 a. Either party giving proper notice. In the absence of an explicit term with beginning and ending date, a court will generally construe the lease to be a tenancy at will, cancelable upon proper notice. 2.52 b. A tenancy from period to period. ERLTA sets standards for improving oral, vague, or unbalanced lease agreements. In the case of an unclear lease expiration date, the lease is generally deemed to be a periodic tenancy. 2.53 a. A hotel. State laws based on ERLTA generally do not apply to transient occupancies, such as hotel and motel rentals, proprietary leases in cooperatives, or to occupancy in a residence that is under a contract for deed. 2.54 C. A temporary possessory interest. A lease is both an instrument of conveyance and a contract between principal parties to uphold certain covenants and obligations. As a conveyance, a lease conveys an interest, called the leasehold estate, but does not convey legal title to the property. For this reason, a leasehold is also called a less than freehold estate. 2.55 D. A leased fee estate. In conveying the leasehold estate, the landlord acquires a leased fee estate, which entails the rights to receive rent, repossess the property following the lease term, and monitor the tenant's obligations to maintain the premises. 2.56 C. Occupy the property. The legal essence of a valid lease is that it conveys an exclusive right to use and occupy a property for a limited period of time in exchange for rent and the return of the property after the lease term is over. 2.57 A. The buyer acquires title subject to the lease, which remains in effect. The landlord may sell, assign, or mortgage the leased fee interest. However, transferring and encumbering the leased property do not extinguish the obligations and covenants of a lease. Buyers and creditors, therefore, must take their respective interests subject to the terms of the lease. 2.58 C. When either party gives proper notice. In the absence of an explicit term with beginning and ending date, a court will generally construe the lease to be a tenancy at will, cancelable upon proper notice. 2.59 C. A 5-year lease must be in writing to be enforceable. Generally, a lease for a period exceeding 1 year cannot be oral but must be in writing to be enforceable because of the statute of frauds. 2.60 B. The original tenant retains primary responsibility for performance of the original lease contract. In a sublease, a transfer of a portion of the leasehold, the sublessor, original tenant, remains primarily liable for the original lease with the landlord. The subtenant is liable only to the sublessor. National Test 3, Land Use Regulation and Control, Legal Descriptions, Contract Law 3.1, D. Zoning ordinances are a primary means of keeping land use in harmony with the master plan. The master plan fuses state and regional land use laws with local land use objectives that correspond to the municipality's social and economic conditions. The completed plan becomes the overall guideline for creating and enforcing zones, building codes, and development requirements. 3.2 C. Specify usage for every parcel within the zoning authority's jurisdiction. The intent of zoning ordinances is to specify land usage for every parcel within the jurisdiction. In some areas, state laws permit zoning ordinances to apply to areas immediately beyond the legal boundaries of the city or county. 3.3 B. To separate land uses so that they do not interfere with each other. One of the primary applications of zoning power is the separation of residential properties from commercial and industrial uses. proper design of land use in this manner preserves the aesthetics and value of neighborhoods and promotes the success of commercial enterprises through intelligently located zones. 6 common types of zone are: residential, commercial, industrial, agricultural, public, and planned unit development, PUD. 3.4 C. The public interest. The principal forms of exceptions to a conforming use is legal non-conforming use, grandfathered in, variance based on hardship, and special exception based on the public interest. 3.5 D. The area of a commercial or industrial facility in relation to the size of the site. Commercial zoning regulates intensity of usage by limiting the area of store or office per site area. Intensity regulation is further achieved by minimum parking requirements, setbacks, and building height restrictions. 3.6 C. It requires that multiple tracts of land be developed according to a single design. Planned unit development zoning restricts use to development of whole tracts that are designed to use space efficiently and maximize open space. A PUD zone may be for residential, commercial, or industrial uses, or combinations thereof. 3.7 A. A homeowner in a residential zone converts her residence to a private school. A legal non-conforming use can be illustrated as follows. A motel is situated in a residential area that no longer allows commercial activity. The zoning board rules that the motel may continue to operate until it is sold, destroyed, or used for any other commercial purpose. An illegal non-conforming use is one that conflicts with ordinances that were in place before the use commenced. For instance, if the motel in the previous example is sold, and the new owner continues to operate the property as a motel, the motel is now an illegal, non-conforming use. 3.8 B. A variance is granted by the zoning board if the owner has a justifiable reason. A non-conforming use is one that clearly differs from current zoning and is subject to change upon conveyance. A zoning variance allows a use that differs from the applicable ordinance for a variety of justifiable reasons. 3.9 C. Certificate of occupancy. Building inspectors inspect a new development or improvement for code compliance. If the work complies, the municipality or county issues a certificate of occupancy which officially clears the property for occupation and use. 3.10 C. It conveys legal title to the acquiring entity. Eminent domain allows a government entity to purchase a fee, leasehold, or easement interest in privately owned real property for the public good, regardless of the owner's desire to sell or otherwise transfer any interest. In exchange for the interest, the government pays the owner a just compensation. To acquire a property, the public entity initiates a condemnation suit. Transfer of title extinguishes all existing leases, liens, and other encumbrances on the property. 3.11 D. Parties responsible for improper disposal of hazardous waste could be charged for the cleanup costs. Under CERCLA and the Superfund Amendment of 1986, current landowners as well as previous owners of a property may be held liable for environmental violations, even if innocent of a violation. Sellers often carry the greatest exposure, and real estate licensees may be held liable for improper disclosure. 3.12 A. Individual property rights and the public's interest. The optimum management of real property usage must take into account both the interests of the individual and the interests of the surrounding community. While maintaining the value of an individual estate is important, the owner of an estate must realize that unregulated use and development can jeopardize the value not only of the owner's estate but of neighboring properties. 3.13 C. Police power. At the local level, county and city governments control land use through the authority known as police power. The most common expressions of police power are county and municipal zoning. 3.14 D. The owner must sell the property in exchange for market value compensation. Eminent domain allows a government entity to purchase a fee, leasehold, or easement interest in privately owned real property for the public good, regardless of the owner's desire to sell or otherwise transfer any interest. In exchange for the interest, the government pays the owner a just compensation. 3.15 A. Reasonably promote community health, safety, and welfare. Local planners do not have unlimited authority to do whatever they want. Their zoning ordinances must be clear in import, apply to all parties equally, and promote health, safety, and welfare of the community in a reasonable manner. 3.16 D. To ensure that improvements comply with codes. Local governments enforce zoning ordinances by issuing building permits to those who want to improve, repair, or refurbish a property. To receive a permit, the project must comply with all relevant ordinances and codes. 3.17 B. To regulate the density of dwellings in the residential zone. Residential zoning regulates density, by limiting the number and size of dwelling units and lots in an area. 3.18 A. A special exception. A special exception grant authorizes a use that is not consistent with the zoning ordinance in a literal sense, yet is clearly beneficial or essential to the public welfare and does not materially impair other uses in the zone. 3.19 C. A legal nonconforming use. An illegal nonconforming use is one that conflicts with ordinances that were in place before the use commenced. For instance, if a motel that was allowed as a legal nonconforming use is sold, and the new owner continues to operate the property as a motel, the motel is now an illegal, nonconforming use. 3.20 B. A plat of subdivision. In addition to complying with zoning ordinances, a developer of multiple properties in a subdivision must meet requirements for subdivisions, including submission of a plat of subdivision. 3.21 A. Accurately identifies the boundaries of the property as distinct from all other properties. A legal description of real property is one which accurately locates and identifies the boundaries of the subject parcel to a degree acceptable by courts of law in the state where the property is located. The general criterion for a legal description is that it alone provides sufficient data for a surveyor to locate the parcel. A legal description identifies the property as unique and distinct from all other properties. 3.22 C. reference points, angles, and distances. A meets and bounds description identifies the boundaries of a parcel of real estate using reference points, distances, and angles. The description always identifies an enclosed area by starting at an origination point, called point of beginning, or POB, and returning to the POB at the end of the description. 3.23 b. Two consecutive common meridians. The vertical area between consecutive meridians is called a range. A range is identified by its relationship to the principal meridian. All ranges are 6 miles wide. 3.24 c. Two consecutive parallels. The horizontal area between two parallels is called a tier, or a township strip. A tier is identified by its relationship to the base parallel. All tiers are 6 miles wide. 3.25 b. 6 miles by 6 miles, or 6 miles square. A township is the area enclosed by the intersection of two consecutive meridians and two consecutive parallels. Since the parallels and meridians are 6 miles apart, a township is a square with 6 miles on each side. Its area is therefore 36 square miles. Remember to differentiate square miles from miles square. 4 square miles is a measure of area, 2 miles x 2 miles, 4 miles square is a representation of the sides of a square, 4 miles by 4 miles. 3.26 d. 1/64. The size in acres of a subsection of a township is a fraction of 640 acres, since there are 640 acres in a section. Thus 10 acres is 10/640, or 1/64 of a section. 3.27 d. Properties in a subdivision. The recorded plat method, also called the lot and block system, is used to describe properties in residential, commercial, and industrial subdivisions. Under this system, tracts of land are subdivided into lots. The entire group of lots comprises the subdivision. In a large subdivision, lots may be grouped together into blocks for ease of reference. 3.28 c. Meets and bounds. A meets and bounds description identifies the point of beginning and describes the distance and direction from that point to the first monument, and thence to subsequent monuments and back to the beginning to define the property's enclosed perimeter. 3.29 d. 36. The rectangular survey system divides a township into 36 sections. 3.30 a. 640. Each side of a section is 1 mile in length. Thus the area of a section is 1 square mile, or 640 acres. 3.31 c. Something of value traded in exchange for something of value. A contract must contain a two-way exchange of valuable consideration as compensation for performance by the other party. The contract is not valid or enforceable if just one party provides consideration. Valuable consideration may be something of tangible value, such as money, or something the party promises to do. It may also be something intangible that a party must give up. 3.32 a. Contain a legal description of the property. In addition to satisfying the requirements of a valid contract in general, a contract that conveys an interest in real estate must be in writing, contain a legal description of the property, and be signed by one or more of the parties. 3.33 d. A reasonable time, or until the expiration date on the offer. If an offer contains an expiration date and the phrase time is of the essence, the offer expires at exactly the time specified. In the absence of a stated time period, the offeree has a reasonable time to accept an offer. 3.34 b. The buyer's death terminated the offer. Any of the following actions or circumstances can terminate an offer: acceptance, rejection, revocation, lapse of time, counter-offer, or death or insanity of either party. 3.35 c. A contract for the sale of undeveloped land. A real estate contract that is not a personal contract for services can be assigned to another party unless the terms of the agreement specifically prohibit assignment. Listing agreements, for example, are not assignable, since they are personal service agreements between agent and principal. Sales contracts, however, are assignable, because they involve the purchase of real property rather than a personal service. 3.36 b. The parties act as if there is a contract. An implied contract is an unstated or unintentional agreement that may be deemed to exist when the actions of any of the parties suggest the existence of an agreement. 3.37 b. A sale contract before closing. An executory contract is one in which performance is yet to be completed. A sales contract prior to closing is executory. While the parties have agreed to buy and sell, the buyer has yet to pay the seller and the seller has yet to deed the property to the buyer. 3.38 a. Both parties promise to do something in exchange for the other party's performance. A bilateral contract is one in which both parties promise to perform their respective parts of an agreement in exchange for performance by the other party. An example of a bilateral contract is an exclusive listing. The broker promises to exercise due diligence in the efforts to sell a property, and the seller promises to compensate the broker when and if the property sells. 3.39 c. The broker may have a claim for marketing expenses expended during the listing term. The damaged party may elect the following legal remedies: rescission, forfeiture, suit for damages, or suit for specific performance. However, the broker must show that the seller has breached the contract. 3.40 d. The failure of a party to perform according to the terms of the contract. A breach of contract is a failure to perform according to the terms of the agreement. 3.41 b. The act of declaring that a contract is no longer in effect for a given party. Parties to a contract may rescind a contract by mutual consent, or a damaged party may rescind a contract unilaterally. This act of rescission cancels the contract and returns the parties to their pre-contract condition, including the refunding of any monies already transferred. 3.42 a. Reflect a mutual understanding or agreement. Mutual consent, also known as offer and acceptance and meeting of the minds, requires that a contract involve a clear and definite offer and an intentional, unqualified acceptance of the offer. 3.43 C. Unenforceable. A valid contract that is in writing is enforceable within a statutory time period. A valid contract that is made orally is also generally enforceable within a statutory period, with the exception that some contracts are enforceable only if they are in writing. These laws apply in particular to the transfer of interests in real estate. A void or voidable contract was not a truly valid contract. 3.44 B. Is possibly valid and enforceable. Incompetent parties, or parties of unsound mind, may not enter into enforceable contracts. However, during the period of one's incompetency, a court may appoint a guardian who may act on the incompetent party's behalf with court approval. 3.45 C. A counteroffer. By changing any of the terms of an offer, the offeree creates a counteroffer, and the original offer is void. At this point, the offeree becomes the offerer, and the new offeree gains the right of acceptance. If accepted, the counteroffer becomes a valid contract provided all other requirements are met. 3.46 D. Valuable consideration. Valuable consideration can be something of tangible value, such as money, or something a party promises to do or not do. For example, a home builder may promise to build a house for a party as consideration for receiving money from the home buyer. 3.47 C. Is void. The content, promise, or intent of a contract must be lawful. A contract that proposes an illegal act is void. 3.48 A. Must act within a statutory period. The statute of limitations restricts the time period for which an injured party in a contract has the right to rescind or disaffirm the contract. A party to a voidable contract must act within the statutory period. 3.49 B. Require certain conveyance-related contracts to be in writing. The Statute of Frauds requires that certain contracts must be in writing to be enforceable. Real estate contracts that convey an interest in real property fall in this category, with the exception that a lease of 1 year's duration or less may be oral. 3.50 B. The buyer has no obligations to the seller whatsoever. The mutual consent required for a valid contract is reached through the process of offer and acceptance. If the offeree accepts all terms without amendment, the offer becomes a contract. The exact point at which the offer becomes a contract is when the offeree gives the offerer notice of the acceptance. If an offer contains an expiration date and the phrase "time is of the essence," the offer expires at exactly the time specified. National Test 4,